A lot of money was spent on this wedding. It was lavish and it was huge. The parents had made a gift of $250,000 to the couple to purchase their first home. But unfortunately, 3 months later, the couples separated.
They were giving $250,000, but now they cannot recoup that.
Our clients that come to us, when they are giving money to their kids, they ask how to do it. They want to know how to document it.
You should put a mortgage on that house or put like a claim on that house as a creditor. If you give money to the kids and the house is going to be matrimonial home, you better make it a loan.
There was no documentation, no legal agreement
Right.
of any sort from the parents to the kids.
And make sure that it clearly states that the parents have given money directly to their son or daughter.
For under CRA's rules, if you're not legally divorced, you're still related.
This is where we get into, as tax professionals, into this space of divorces and taxes where we have to figure out what asset the couple can agree to do the transfer.
Okay, Sunny, let me tell you a story. So I went to a wedding last year. It was a South Asian wedding. So as you know, there's 1,000 people there, and a lot of
Only
money.
1,000 people.
Only 1,000 people,
Yeah.
and a lot of money was spent on this wedding. It was lavish and it was huge, and it was exciting for the couple. But unfortunately, 3 months later, the couples separated.
Wow.
Yeah,
Okay.
they went their own way, and the parents had made a gift of $250,000 to the couple to purchase their first home together, which they lived in together. So what do you think happened
So it was
to...
their matrimonial home.
Yes, it was.
Okay.
So what do you think that happened to the $250,000?
Let me ask you a few questions.
Sure.
Did they document the loan?
They did not document the
They
loan.
didn't say it was a loan. They didn't say it was a gift.
No,
They
there
just
was
kind of
no...
left it.
There was no documentation,
Unassumed.
no legal agreement
Right.
of any sort from the parents to the kids.
Okay, so if they'd said nothing, then it looks like they made a contribution, which looks like a gift in my mind. In absence of any evidence, like it's not a loan, so it must be something like a gift. Contribution to a home that is owned by the couple, that is their matrimonial home, then it creates entitlement
Yeah.
for the couple because now it's going to be split right down the middle, basically. So the $250,000 that the parents gave, half of that down payment inadvertently now went to each of them, and the parents get nothing out of it. I mean, they made a gift. I don't think they were expecting any. I think, but like to their daughter, they were giving $250,000, but now they cannot recoup that.
Yeah.
That is very, very unfortunate.
Yeah. And there was a lot of money spent on the wedding as well.
Yes.
So there was a lot of money lost.
Yes.
But yeah, they were expecting to recoup it for sure.
But I think if they had taken some advice, perhaps, or even thought about this, potential outcome, not that somebody tries to, think about their kids getting divorced, but I think things do cross in mind when they're giving such a big check for a down payment, right? Like, how can you protect yourself? So I think it'd be easier to talk about okay, if they had given this $250,000 as a loan to the couple, typically, I mean, I hear this all the time where we would want to structure this $250,000 as a loan.
Yeah, typically our clients that come to us, when they are giving money to their kids, they ask how to do it, right? They want to know, will this money be protected in any sort of way, right? They want to know how to document it.
And I think they go one step further when we tell them. It's like, I mean, we're not lawyers, but we come across these situations commonly, so we know we can speak about them. But commonly, the advice is also given that you should put a mortgage on that house or put a claim on that house as a creditor or a lien on that house, so that not only that the loan is there, but you're also secured with the loan. So in case the house needs to be sold, you're one of the creditors that's going to be paid along with the bank who has given the mortgage on top of that. So you're no different than the bank.
Yeah.
So you're never going to lose on that $250,000.
Yeah.
So I'm assuming that wasn't done. So let's talk about what is equalization. Let me ask you, what if this couple, let's say, same thing happens, they got married and got separated and all that stuff, but the money that the parents had given them did not go to buy the matrimonial home, but instead, let's say daughter just took that money as a gift, which was implied here, and bought an investment property, let's say a condo in downtown.
Yeah. So if it's not for the matrimonial home, but for an investment property, the gift would be excluded. from the
Excluded
equalization payment.
Right.
Yeah, so if the gift can be traced, right, and the daughter then invested in another property, that amount would be excluded
Right.
from,
Right. So, like, to be clear, this is all Ontario framework,
yeah.
right? Ontario, Canada framework. So the distinction you're trying to draw is that if you give money to the kids for the house, and the house is going to be matrimonial home, you better make it a loan.
Yeah, because that's just an automatic split
Yeah.
50-50.
But if the daughter in this case who's receiving the money from the parents, if they receive that money as a gift, even that's okay, so long as you can trace it back, that the
To the
money
gift.
came from the parents as a gift to the daughter, and the daughter invested it.
And the daughter's on title of that investment
Yeah.
property
She's the sole
or
owner.
whatever investment it may be. She's the sole
Right.
owner of that
Right.
investment.
Right. So then that would not be subject to the 50-50%. I mean, we still have to talk about equalization, the concept,
Yeah.
but generally
Like
speaking,
we're
that's
also
okay.
speaking about it as a concept,
Yeah.
right? Like we're not family lawyers.
Mhm.
But from my
Yeah.
understanding, that's what I've seen, that
Right.
the gift would be excluded if it's traceable.
You have to trace it.
Yeah.
I think where it gets difficult is like, assume some time has passed where like the money has been given by the parents, 250,000. That 250 goes to like maybe, let's say, buying a condo in downtown Toronto. You kept that for 5 years.
Yeah.
Then that condo has been sold for, let's say, some profit, sold for 500,000. They took $500,000 and they put it into another house, and then so on and so forth, continues to be substituted over a period of time.
Yeah.
I think it's going to be, you have to keep a clear trace that the original money, seed money, came from the parents, and that would go a long way in terms of saving that outside of the marriage or equalization payment.
Yeah, exactly. It would get messy if you can't trace it, right? But if it's traced and there's the sole owner is, say in this case, the daughter, any growth from that investment property would be excluded.
So you should even like do a deed of gift, like as a legal document, when even if you give the $250,000 as a loan, you would document it anyways with like repayment terms, etc. And then if it's a gift, you should do a deed of gift paperwork with your lawyer, and then make sure that it clearly states that the parents have given money directly to their son or daughter, and their son and daughter can wish to do whatever they want with it.
Yeah,
And
definitely.
it's not going to be part of their marriage equalization pieces.
Yeah, there definitely should be an agreement either way, a gift or a loan. A loan would
Yeah.
protect the down payment, but otherwise you should have a gift deed.
Got it. So why don't we get into the equalization? We've used the term a couple of times. Let's get into it. So like, what is equalization in the context of Ontario family law?
Yeah, from my understanding, like there's 2 points in times that are important: when you get married, right, and when you get separated. Those point in times, we need to understand what is the net worth of each of individuals that are entering into that marriage, and then what is the net worth individually when they're separating, right? So any growth from when you get married, right, to when you separate, that's split 50-50.
Got it. So, a lot of times people, when they talk to us in terms of divorces and separation, there is a bit of a misconception that I constantly hear from others. They think that if you're going to be getting into a divorce, you're going to have to split everything 50-50. Yeah. If you own RSPs, 50-50. You own a house, 50-50. Investments, 50-50. If you have anything that goes split right down the middle.
No, like each property is not split 50-50.
Yeah. In Ontario, that's not how it works. It's
No.
the equalization concept. So say you have a couple, husband, wife, let's put example names. So, Jonah and Julia.
Yeah.
They get married. Let's assume they have nothing in terms of the value, because a young couple, they don't have much to save or whatever to show. So on the date of the wedding, the snapshot, net worth snapshot, so all their assets minus liabilities on the day of the wedding is like 0. 10 years later, they get separated. And at the time of separation, they have grown a lot as a couple in terms of value, but one has grown more than the other.
Yeah.
So let's say Jonah is worth $1 million in net assets minus liabilities, and Julia is like 800,000. So you can tell, like, Jonah is $200,000 over and above Julia. So you're saying when the equalization happens, they're going to look at that difference of $200,000, which Jonah has more of, and they're going to split that 100, between themselves.
Exactly.
So then in this case, Jonah will owe $100,000 to Julia, so that both of them end up at $900,000 each.
Yeah.
Right? Okay. So then you can basically cherry pick.
Then you can pick which assets to move to who.
Right.
Like whoever is making the equalization payment, right? You can pick what assets you need to sell to make that equalization payment.
Right. So if you can cherry pick anything, so like most commonly from a tax perspective, right, we see transfer of RSPs because you can do them on a tax deferred basis while you're still married. Home, if you have a principal residence, that's another tax-free asset.
Yeah.
I don't know if couples really retain the house sometimes or one takes it over the other.
Yeah.
But usually you would use that to equalize. So in terms of the equalization, what practical issues most people run into? I mean, we used a very simple example of like Jonah and like $1 million and $200,000 being the difference.
Yeah.
So what are the practical issues people run into mostly?
Typically trying to figure out how to make that equalization payment and which assets to sell off. You don't always have that cash laying around, right, to make that payment.
Yeah, you have to sell some assets.
Yeah, so the partner that's actually making the payment that has grown their net worth to be higher, you have to sell some assets.
Yeah.
And it's thinking about which assets to sell, because you do not want to pay the CRA, because you may you have another, you're maybe paying out to one person, right, your spouse, whoever you're making the payment to, but you're also paying the CRA if you're realizing any taxes. Yeah. So you want to strategically pick which assets to sell to make that payment.
Well, yeah, I mean, you bring up a really good point that if you're going to be owing some money to one of the spouses, the transferring person, the spouse, does not want to trigger any taxes in making that payment, equalization payment. And, this is where we get into, as tax professionals, into this space of divorces and taxes where we have to figure out what asset the couple can agree to do the transfer, because you can do in-kind transfer without actually selling the asset and actually converting into cash, and then that cash converted now is after tax paid cash. So, but you may have triggered like 30, 40, 50% rate of tax at that point, depending on the individual. So what you want to do is you want to look at, the exercise that we go over is like, let's get a net worth statement, which they already have prepared for the lawyers anyways, divorce lawyers. So we look at that net worth statement, look at each asset, what's the character of that asset, and then try to figure out, get an agreement between the two couples, like, okay, which assets are you going to cherry pick to make this happen? Do you want the house? Do you want the RSP? Do you want like non-registered accounts? Like, I think we usually leave it to them to figure out what is it that one person wants to transfer and the other person wants to receive.
Yeah, and I think it's important to also know at this time when they do come to us, they're separated, but they're not legally divorced, right?
Yes.
Because for under CRA's rules, if you're not legally divorced, you're still related.
Yeah, you're
right?
Still related.
And in order to do some of these tax plans, we need to ensure
you don't need to be divorced. You should not be divorced by the time to come to us.
No, you shouldn't legally be divorced.
Yes.
Right? You're going through that separation still.
Correct. So, which again, like, you should involve your accountant and tax advisor early on, but at least at a point where you've determined the equalization payment through the lawyers.
Yeah.
Right?
Yeah. So typically the lawyers will have some agreement already made. You've already discussed this between you two.
Yeah.
And now you're just cherry picking what assets.
Yeah. Or we get like sometimes draft separation agreement, which has some language carved out as to what will be transferred.
Yeah.
But the couples are usually at a point where like they're like just exhausted from the process, where they just want to get things done right away, and they don't want to drag it anymore. Or they're like thinking of, okay, in calm minds, they understand there's a break of relationship, they're still cooperative, and they want to properly analyze which is the best method of actually moving the assets one person to another without triggering and paying the tax man.
Exactly. Yeah. Like, because the other person that you're paying is the tax person. But in a reality, not a lot of times are divorces friendly, right?
Yes.
And I think one party might not care if you have to pay the tax man.
Yeah, they don't care.
And that's where it becomes very difficult to deal with that.
Yeah.
But in a perfect world,
Yes.
you know, both parties understand we want to just pay each other and not pay CRA. So they're open for this type of planning, but that doesn't always happen.
So, but generally speaking, if you have, while you're still married, just separated but married, not divorced, you can do you can do transfers between the married couple. And in the framework of our tax system is that we have accommodations within our tax act which recognizes divorce as a reality. And if so long as the transfers happen before the divorce has happened, you're still going to be considered related for tax purposes, and hence there's a lot of tools available to make the transfers without triggering taxes.
Yeah.
So long as the asset is moving, not the asset that gets sold, you convert it to cash, at which point you pay the taxes.
Yeah, you have to transfer the actual
asset.
asset versus cashing it out and then making the payment.
Right. Okay. So, you know, where you just mentioned, like, it's not that easy sometimes. It's not as clean sometimes. Sometimes we're brought into the picture really late, you know, and they may have already sold some asset to convert into cash. And then we're like, oh my God, you've already paid the taxes on this or triggered the obligation to pay the tax. But you're right. Like, people don't care sometimes. Like, if one spouse just needs to receive the equalization payment, they don't care if the other person has to pay arm and a leg on taxes. They just want sometimes that asset right away. And you're pressured into this time crunch to make it all happen. Now, what makes it really interesting in our context or our scenario is that sometimes assets are not owned by one person and not by the other. There's a lot of joint assets also. Home being a very common example, but is tax-free. So even if he sold it, it's not a big deal. Oftentimes, a lot of business owners have their corporations are jointly owned by their spouses. They don't think much obviously you're not thinking about divorces when you're like in their happy part of the relationship and they're starting a business and they set up a company, they put themselves as a shareholder and they give the other 50% to the other spouse and they think they're going to be able to income split and give each other dividends and like there's other tax benefits that you can get. Lifetime capital gains and exemption, we've spoken before on another podcast. So, but if that other spouse is still jointly owning the shares of your business and only one spouse is really running the business, then you really have to buy out the other person.
Yep.
Right?
Well, because they've focused on building that wealth in their business and they focused their efforts on that, right? And so they're going to be looking at that. What is the other person doing if they're not focusing on building a business and providing for the family from a financial perspective? Maybe they're taking care of the kids and staying at home, right?
Yeah, give up their career.
There's still, it's a partnership. Like marriage is seen as a partnership.
Right.
So if they've given up their career and they haven't gone out and built that wealth themselves, there is a form of equalization, like we spoke about, that you have to make. And you're buying,
You have to buy that other person on regardless because you don't
even if they're a shareholder and they're just inactive, right? Typically.
No, you probably don't want the person you're like going to be ex with to be to be jointly owning a business.
No, you should. Yeah.
Right?
No.
Because now you have this other shareholder who has now unrelated, you're not really in good terms and you might just want to part your ways.
Yeah.
Even divorce, family law or not, you just don't want to be partners.
No, because because if you're trying to buy back those shares and you're trying to do all these things in a planning perspective, you need them on board to sign off on documents, right? So, and if there's bad blood, then...
Yeah, that's going to be difficult. So oftentimes we see those examples, right? Like we are brought in, we're like, okay, we've got all these assets that are commingled. Home, investments, we have a business, operating business, investment companies with joint ownership. And we're asked as accountants and tax advisors, can you like help us separate everything and help us buy each other out without paying any taxes?
Yeah.
Right? Or in more tax efficient manner. So let's go through like some of the examples that we have seen just to reinforce some of the concepts as to what typically is involved, what do we do, and what are some of the outliers and extreme cases we've seen that may have gone really bad, or the ones we've seen like actually gone really well. So give us some examples of like some of the outliers or real life examples we both worked on.
So typically we'll ask for a net worth statement, right? So they'll come to us once maybe a separation agreement has already taken place. So we had Jordan and Samantha as an example, and we looked at his net worth statement, right? And we found that him and his wife were both in the corporate structure, and this business was his baby. As owners, and this was his baby, right? His business is what he spent his whole life making. He is the business, and he needed to buy her out. So typically, we'll take a look to see who owns what and where the co-owners exist. And we'll see how we can...
their entire net worth.
Their entire net worth, And we'll need to see, like, what are the tax implications on that buyout, right? Yeah.
So, I mean, in Jordan and Samantha's case, right, like, if they had that same $200,000 of equalization payment, I think the number itself is large enough. You can always make those transfer of assets. Just the commingleness of the assets that they have that we need to really take out.
Yeah, that's the thing that gets complicated, because if you have someone else in the structure, then now we're going to have to look at how can we get them out of the structure in a tax efficient manner.
Right. So, which sometimes is not easy because you may not get cooperation.
Yeah.
You know, the funny thing is that it gets sometimes really messy, where I'm going to use Samantha, Jordan example. Let's say Jordan is the main, like you said, you know, the brains of the business. Samantha is not. She's just there as an owner because Jordan put her in at the beginning, thinking that he might realize some income splitting benefits. So they each are represented by a divorce lawyer.
Yeah.
Then the corporation is a separate person, and it's kind of the subject of these two parties fighting over each other, right? And that happens. Then typically the divorce lawyer will say you need to get a separate corporate lawyer to represent the companies. Companies to be represented separately.
Yeah.
And you might also have sometimes the accounts on each side also looking over each other's shoulder to make sure that the other party is not cheating the other person.
Yeah.
So now you've got two divorce lawyers, one corporate lawyer, two accountants, and maybe a tax advisor on top of that. There's like 6 people potentially.
Yeah.
And there's CRA who might also want to get paid.
Yes.
Right? So a lot of people involved. Things move slow pace sometimes.
Yeah.
Because there's so many people have to like look over making sure things are happening properly. And that whole situation and number of people involved is already, it's always based on like if this is going to be cooperative situation or they are like bickering and fighting over their assets and like lots of tensions going on, because that really decides the environment in which the planning can happen.
Yeah.
Or professionals can work with each other.
Yeah.
Right. So, and sometimes you just lose a lot of money just paying these professionals to make sure things are going on.
Yeah, as things go, it's their time, right, that they'll charge for.
Yeah.
And if things are going slow, which happens when not everyone's friendly, then more professional fees have to pay.
Come in the way. So coming back to the same example where like if Samantha is the co-owner in the company and we need to get her out, you know.
Well, Jordan wanted to keep the business, right?
Jordan wants to keep the business, Samantha needs to be out.
Yeah, so he had investments that he's, you know, typically when you're running your business, you reinvest in your business, but as it makes profits, you're going to go invest in that, right? And these are your portfolio investments, your RSPs, and everything that your cash that you're sitting on. So if he wants to keep the business, which is his baby, which he did, he had to give up all the cash. You have to give up something.
Well, if he has RSPs or he has like other assets outside of the company, you know what? Typically it's a house that I think gets a lot of that relief, that tension. Because like Jordan might be entitled to 50% of the value of the house in typical case in Ontario. And if the house is sold, they get cash. Jordan can take his 50% of the entitlement and give it to Samantha. Yeah. And then that's in lieu of the value of the shares. Yeah. But then the main thing is like you got to get the shares valued. You need you know how you had 6 people? Guess what? The 7th person. Yeah.
You have to value the business. You have to value the business.
You got to get an appraiser or evaluator, chartered business valuator to go and assess what is the value of the business here. And once he determines or she determines the value of the business, then you can take that value and figure out what Jordan is going to give up for the same value in order to make Samantha whole. and then Samantha can really give up the value in the shares in the company.
Exactly.
Right. So it's really a bit of economic exercise. You're trying to make sure both parties come ahead, and they both have now been untangled with the assets that they have. But it takes time, it takes effort, and depending on how many professionals are involved, it can get messy.
Yeah, for sure. And like with Jordan, he became cash poor after. He has his business, right? And he's happy he was able to keep it. But he's just left with the business.
Yeah.
And, all his cash is gone. And leaving that cash poor is not a good feeling.
Which is true. Like, I think you said something really practical, which most people do not think of. I think they're so like in the mix of like getting the divorce done, because he had to keep business, which is really, there's no cash sometimes to it. Yeah. Its business value is...
It's an intangible asset, right?
It's an intangible asset. If he sold the business, he'll get money for it. Mm-hmm. But until he keeps the business, he's going to have to just live with what the business makes, right, over time. But Samantha, in this case, has taken all the liquid assets sometimes. Mm-hmm. She'll take the half of the value of the house, if it's been sold, maybe liquid investments that Jordan had to also give up, maybe his RSPs, just so he can like keep the business.
Yeah.
And
it's difficult to live life that way, right? Because you don't have the cash to pay for things. You don't know when you'll need that cash.
Yeah.
Unless you sell your business. So.
Right. So.
Which is not an easy process either.
No, it isn't. I think it's not a bad idea to like even understand like how do you even value that business, right? How do you value the shares of the person who is giving up the shares?
Yeah.
I had recently seen a valuation report in the similar context, right? Not Jordan and Samantha's file, but let's assume there's one. In which case, the valuator interestingly looked at the business. He said, the business really is, let's say, Jordan.
Yeah.
He is the business. Without him, the business fails. Mm-hmm. The business has no value without him.
Yeah.
So, but if Jordan sells this business in the market to somebody else, he can make efforts to create more. He can create a transition plan. He can make sure that the buyer comes in and buys the business in a way that they will be successful and they will see value in it. Jordan can even become an employee of the business to make sure the transition happens. So he can basically maintain the value should he wanted to. Mm-hmm. Then he looked at this other option. He said, okay, Samantha's leaving the business. What's her shares worth? Business can certainly run without her because she's not involved in it. The only person, because she's a minority shareholder, meaning like 50-50, meaning like she can't really run the business without Jordan.
Yeah.
Her market of selling the business is only Jordan. Mm-hmm. She can't go sell it to somebody. No one else will buy it from her. Jordan is the only person who can buy it. They actually applied a discount to the purchase price. They said, if Jordan sells it, the value is a lot higher because he can do a lot of stuff to make sure the business is continuing and going, etc. But if Samantha is selling, she's going to be looking at least 30-40% discount of its value.
Which makes sense.
Yeah. So, which I think is interesting in this particular context, that the valuators give a lot of thought, although it's subjective, valuation is always subjective, but they're independent. They're looking at specificity of the situation, and they're looking at the context of how business run, who is responsible for it. And then, in this case, now Jordan can buy out Samantha for like 60% of the value of what Samantha would otherwise receive if they kept together as a couple and actually sold it to somebody else.
That's interesting.
So now Jordan has to come up with the value, and basically we spoke about, he's got to give up RSPs or investments to make up the value for it.
Right, yeah. So a lot of times our clients come to us, right, to do other types of tax planning. Families come to us. They have companies, right? They have a business, and they're looking to introduce the next generation now, right? Mm-hmm. And a lot of the questions that come up is, if I'm going to give my children the level of wealth that I've built, is it protected under family law if they get married?
Yeah.
Right? And that's always their concern when they come in for tax planning, that they know they want to pass this business down, but they also have these questions, right? Will this be subject to any future disputes when it comes to marriages.
It's a very
And-
common question that we always see when we are looking at business owners and we're telling them, hey, if you want to do your estate planning, you need to bring in next generation into the ownership of the company now and not wait too long. But it always becomes a subject of discussion almost every single time, where they're having insecurity that if they were to bring in the next generation, what would happen to their business or wealth? Will it now be commingled with divorce and marital breakdown? And now that is subject to 50-50 of, equalization payment that we're talking about.
Yeah,
Will
which
their
makes
assets
sense.
be commingled now because of it?
Yeah, no, it makes sense. They've worked so hard for their business, right? They've built this level of wealth. They're ready to give it to their kids. But when their kids get married, they're afraid it might just go away, right?
Yeah.
So what are some of the measures that we take? Maybe speak to that.
Yeah.
Say, for example, they're ready to bring direct ownership into the corporations and give kids that.
Yeah, so assume like you've got a corporation, has an active business, runs like a successful operating company, and let's say, both parents are on it as shareholders, so they own the company together. And now they're thinking that, they're in their 60s, they want to continue running the business, maybe pass it down to their next generation, and they continue to run the business maybe. And they would like to introduce the kids as owners, shareholders in the business. Very commonly they'll raise the question to us is that if you were to do that, will it be now commingled in their marriage breakdown and all that stuff for the kids? And typically it's a common concern, and we're always looking for alternatives as to how we can do that. Option one typically is that, very commonly you do an estate freeze. We've spoken previously in the podcast, which is basically a tax-deferred way of bringing in the next generation in, and which typically involves you to do some share exchanges. So parents give up their existing shares, which are growth shares, for like fixed value preferred shares, which do not grow anymore. So this is a share swap. That happens without paying any taxes, so long as you meet some conditions, you've structured it properly. And then new shares are typically issued to the next generation.
Yeah.
And let's say, we've got like two kids, adults, and they both want the shares in the company. Let's say 50-50. This is where you need to be really smart. And I think you can consult your family law, because I'm not giving any family law advice here. But typically, there are two options of giving shares in the operating company here. Option one, the kids pay for the shares themselves. Nominal value, they can give company, let's say $100, $50
Yeah,
each.
because at this point we have frozen the value
Yes.
with the parents. So the parents still sit with that value. And
they
now
have
we're
the preferred shares with the equal value of the company.
Okay.
So then we have to now get the kids to buy into it. New shares, common shares, which will be participating to the kids. So kids can give $50 each nominal amount, and they get their shares.
So they'll get the future growth from that point on, and they've subscribed to those shares.
They paid for it. They subscribed to it. It's their shares going forward, and that's it. It's them. Which is one way of doing it. But then now, how you were going about like describing the equalization payment, where you look at the snapshot of the couple who's divorcing on the date of their wedding versus the date of the separation. And now you have to see, well, what is the value of increase? And then there will be an equalization payment that will be determined. Well, if you subscribe for these shares personally, then that increase in net worth will be part of that calculation. But remember, there's an exclusion that we had previously also mentioned. Like if there's a traceable gift given by a third party, such as your parents, to that child, then it can be, you don't have to include that within the equalization payment calculation based on Ontario family law. So typically, you would want to take that extra step when you're issuing shares. You issue shares not to the kids directly. You issue shares, new shares, which have no value in them, $50. The parents should pay for that $50 themselves. They become the shareholders. So now at this point, they own preferred shares for the value that the company that hasn't grown until now.
And common shares.
And common shares, which have no value. And then now they can take those common shares and gift that to the kids.
Yeah, so this way you can trace it back that this was a gift from my
A,
parents.
you did not pay any taxes to bring them in.
Yes.
B, you also want to give it a gift, which is
Yeah.
excluded from the family law in Ontario for the equalization.
Yeah,
movement.
that makes it much more clean to trace back. If there is a dispute with the child and their spouse, then they can see that this was given as a gift and this, I'm the sole
They'll see
owner
it in
of
the minute book that the first shareholders
Yeah.
were the parents, and the next, then it was transferred by
And it's signed by both parties.
Both parties. They'll have a deed of gift, all the legal documentation is king. Like, you got to document everything properly. So a lot of times the parents will like, yep, let me go through this ringer of extra steps to make sure I'm protected, so that one day, if this ever becomes an issue, we can prove that the kids did not, suddenly create the value for themselves by themselves, which is subject to equalization. It was actually gifted to them. They were brought in, and it was my gift to them that now they have this value.
Yeah.
But if it's not structured properly by taking a misstep, you might be out of luck.
Right.
Basically.
So a lot of that does happen
very
sometimes.
nuanced.
Yeah, it's very nuanced, and we do see this often. But a lot of times, parents, from a parent's perspective, they're not ready to bring the children into the company
That's
directly.
another,
Right? Like, they may be 60, but they're still working at their business. Their kids might not be old enough or not ready to take on. The parents don't feel that they're ready to have direct ownership and legal title over the value of the company.
Or they may not be even running an active business. It might be like an investment holding company.
It could be an investment.
And the kids they just want to give them access from an estate planning perspective, bring the kids in, not from the point of view of giving any value today, but so that they can reduce their taxes on debt. That's like an estate planning objective.
Yeah,
altogether.
like they're coming because they want to just freeze the value that they have from a tax perspective. But they want to do that. But there's what we usually do is introduce a family trust.
Yes.
Right? So how does that play a role? What are the parents' fears that we've seen?
I mean, very, very commonly, right? If you think about a family trust, so in the same example, the parents now have preferred shares. They can introduce the common shares can be given to the family trust. A family trust has, trustees who manage all the affairs of the trust. Typically, that's the parents' role.
Yeah.
And then there's beneficiaries to whom the future value will accrue via the trust. Beneficiaries typically don't have any claim. They don't have any rights. They have a future participation in the assets of the trust should the trustees decide to give them income or the shares of the company in the future. So it's very discretionary in nature, and it adds a layer between the company as an owner of the company, and the kids, because there's a trust in the middle. And the trust basically is controlled by the parents. So at the end of the day, you haven't really given them anything, but from an estate planning perspective, you also brought them into the mix. That future growth doesn't accrue to the parents directly. The kids can come into the ownership of the trust.
There's an option for the kids to come in. You've not given anything.
You have created flexibility now.
Yes,
right?
It's a flexible
and there's tax.
structure.
It's very tax efficient. I mean, there's a different podcast altogether to that, so you can always go and watch that.
Yeah.
But at the end of the day, parents are still concerned. Hey, what if somebody, got into the trust like a spouse and they had a claim on their trust now?
Yeah, because you name all the
beneficiaries,
kids. You name all the beneficiaries. So you put their names, and any grandchildren that the parents have, they're all typically beneficiaries.
Yeah, well, then you would exclude the spouses of the beneficiaries as beneficiaries of the trust.
Yeah.
I mean, that's a given, right? Don't put, I mean, you can put, the parents themselves, the husband and wife, now their children, their grandchildren, but don't put the spouses of the others.
Yeah.
So if you did that, you have at least taken the first step that because they're not beneficiary, they can never contest. That's number one. Number two, practically speaking, what we have done is created some clauses in the trust that says that if certain event is happening in the beneficiaries' lives, they're automatically suspended as beneficiaries. So let's say an adult child that's going through a divorce, suddenly, as long as the matrimonial dispute is going on, they're no longer beneficiaries. Even if the trustees wanted to give them something while they were going through a divorce, they just can't.
It's an automatic out.
And then soon as they're done with their matrimonial disputes, everything is settled, that's when they are brought in as beneficiaries automatically.
Yeah.
right? Again, this is more of a bells and suspenders. I think family law still has a lot of discretion sometimes in certain cases, but I think you can still take this additional layer of protection where you don't name the spouses as beneficiaries, and if you do, you create this event of like their benefits are suspended from the trust if and ever they go through this matrimonial dispute, amongst other things, such as bankruptcy as another example. And then the third thing you can potentially do is the trust, I mean, depending on the lawyer that drafts the trust, can create very specific language, and I've seen this, whereby they'll clearly say that the benefit is not meant for the spouses, even though, I mean, they're not in the trust to begin with, but they'll very specifically say the intention of the trust is never to benefit the spouse. And again, it's like another layer of protection. But lastly would be, which you can speak more of, is like the prenuptial agreement, the prenup or the marriage contract.
That's like one of the main ways that you can protect yourself, is having a marriage contract.
That would be the most ideal.
Which will specifically exclude what you want it to exclude. Because otherwise, family law does have a lot of discretion.
Yes. So like, a lot of times parents are told, make sure your kids get a marriage contract.
Yeah.
But in practicality, oh man, like nobody wants to, it's such a taboo topic, at least in some cultures, that the parents will not be comfortable speaking about it, because that might strain the relationship. And if they have the courage or like comfortableness to speak about it, the kids might just say, no, forget, I'm not doing this. Yeah. Right? So
and I think sometimes it's like a lack of education too. The kids don't understand why. They don't know the nuances of what could happen, and they're entering this marriage on a positive manner, not to plan for maybe a divorce, right?
Yeah, and but
from the parents' perspective, they're afraid because divorce is real, right? It does happen, and it happens to a lot of people, unfortunately. And a marriage contract will at least lay out exactly.
Well, it'll say everything.
It'll say everything.
It'll say like nothing that this person, my child has, will be subject to equalization payment at all.
Exactly.
Right? And even more. There's be much more coverage.
Yeah, and it's a conversation that a couple would need to get into to see what's fair to them. Yeah. Right, but at least it's planned for.
Well, one of the families that I saw, they very carefully had this idea very early on, whereby the family is very successful, has lots of wealthy family, and they knew that they had this insecurity that whoever's going to come into this family and marry into the family, they might have motives of like getting money and like eventually divorcing the kids, etc. So they want to make sure the kids are protected. So very early on, even in their teenage years, they were doing family counseling.
Yeah.
Like I know it sounds really strange.
Yeah.
But when you have that kind of money that's like floating around within the family, they take all the steps that the kids realize very early on in their formation years, that marriage contract is basically essential for them and this family's wealth to survive and not just been given away.
Yeah.
So they might be, in excitement at the time of the marriage to be married, and bringing up something like this sensitive so close to the wedding might not be very convincing because of the timeline is so close. You just can't convince somebody.
Yeah.
But if you brought that issue or broached that topic very early on from the beginning,
and they'll know that this is just something
this
that
is
we
an
need
expectation,
to do.
right? They can say this is an expectation,
Yeah.
and you keep like repeating that to them over their lives until they get married. It won't be a conversation that is too difficult to have with your partner. The kids won't have that difficulty in having that conversation.
Yeah, the kids won't have difficulty. I'm not sure how the person receiving it will take it, but
but they'll make it clear early on in their relationship.
Yeah, that this is what they expect.
Yeah. There won't be a sudden news to somebody that, look, we don't think we trust you. They can just say, hey, they're dating or whatever. They can just say, hey, my parents would absolutely want this, and this is one of the conditions of us getting together.
Yeah.
And if that's something that everybody's comfortable with, I think you can do a lot more with it.
Yeah, exactly. It's good communication to have early on.
Yeah. I mean, it's also from the parents' perspective, you're protected, but like we haven't spoken about how can also be, useful for the kids themselves, right? Like we were talking about Jordan and Samantha, and I mean, they had commingled ownerships, but like we saw an example of a very successful doctor,
Yeah.
right? We should maybe talk about that example.
Yeah. So in that case, the doctor was making around $1 million a year almost. She was a
Very successful.
Yeah, successful,
Young and
specialized,
successful.
young doctor working, making a lot. And her husband was making around $200,000 in salary, but she had an inheritance coming from her family, right?
Yes.
So it was made very clear to her that a marriage contract was needed in the very beginning.
But they took it they went one step further, right?
Yeah.
They said that in the marriage contract that whatever money she makes from her, medicine, professional services, being a doctor, let's say $1 million a year, none of it will be counted towards the equalization payment in the future. So whatever she does with that money and then further on creates more investments from it and those investments grow, nothing will be counted towards the equalization payment. And I cannot believe that contract when I heard they went like,
you can take it too far as well.
Clause by clause, this clause doesn't apply, that clause doesn't apply in the family law. This they went through it all and negated every single thing. It was very thick.
I've seen a couple
contract.
of those actually,
And but I think they also kept few things intentionally, right? They said, okay, if the person who is contributing more to the marriage because they basically make more money, when they put the kids to private school, it's okay. They had some stuff like that.
Yeah.
If they choose to make joint investments purposely, like they actually commingled into like joint assets, that's going to count towards the equalization payment.
Yeah, which we talked about a little bit. When it's joint,
so they would
then
be purposeful.
Yeah.
Right? If they kept separate, it's not. But if they jointed, then they would be.
It's purposeful. They made that intention to put this together, maybe for their children.
Yeah, and then the matrimonial house, they also said that it would be split half-half.
Yeah.
So I think they kept some concessions that they felt like was useful. But I think the big win for the family themselves, like, okay, nothing from the inheritance will be subjected to the equalization payment.
Yeah.
And then whereby, the wife is making a lot of money, none of that plus any investments or any substitutions of those assets will ever be subjected to investments and equalization payment.
Yeah.
So, I mean, you could take all these steps to protect yourself and not end up like Jordan and Samantha, where you've done like, little to no planning sometimes. And you just added without much thought, to the shareholdings, and now you have to really fix
untangle them.
Untangle them, right?
Yeah.
So you can be deliberate and purposeful.
Yeah.
At the end of the day.